everyone. Thank you for tuning in today and welcome to Family Law Now After Hours. Before we dive into today's topic, which, as you may have heard, is dealing with child support and understanding and calculating child support in Ontario, just a quick few housekeeping items that I want to make note of before we start. Also, while we're here to provide valuable insights on separation, divorce, and other family law matters, please remember that any information shared in this series should not be taken as legal advice. So as I said, our topic for today, which is really wide open, is calculating and understanding child support in Ontario. We'll be covering a variety of aspects that shed light on various child support matters. And always, if you have any personal inquiries about your specific situation, we highly recommend reaching out to our office or consulting with a lawyer in your area to get tailored personal advice. Now I'm going to go along with some introductions. So up first, Shanza. She is a recent law graduate from Osgoode Hall Law School and is an articling student at the firm. And she has plans to be called to the Bar of Ontario in June 2024. She's focused on launching her legal career in family law and is dedicated to providing empathetic and proficient legal support for those navigating family-related complexities. Her valuable experience stems from active participation in legal clinics, mooting competitions, and prior work as a legal assistant. As she embarks on her legal journey, Shanza is poised to contribute to the firm's commitment to excellence in family law, leveraging her diverse background and unwavering dedication. Russell Alexander is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. With over 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them cope with the difficulties of separation and divorce. Russell has written 4 books, all great reads, and is a fully trained collaborative practice lawyer, and he speaks at conferences on collaborative practice, marketing, technology, and the law all over North America. Steph has been with the firm since 2018, and she was called to the Bar of Ontario in 2022 and is now an associate lawyer at the firm. Steph has completed her undergraduate degree at Queen's University and obtained her law degree from the University of Liverpool in 2020, graduating with first-class honors. And Steph, like all the other lawyers you see on your screen, or soon-to-be lawyers, I should say, on your screen, she is also trained as a collaborative practice lawyer, and she's committed to assisting clients through what is traditionally a difficult time by approaching matters with empathy, integrity, and compassion. Last but not least, there's me. I'm an articling student at the firm as well, and I'm set to be called to the Bar of Ontario in June 2024. I'm a graduate of Ted Rogers School of Management at Toronto Metropolitan University, formerly Ryerson University, as well as the Queen's University Faculty of Law. And as I enter the next phase of my legal career, I'm committed to positively influencing the lives of those facing difficult family situations. And outside the office, I indulge in playing hockey, unwinding with comedy movies, and cheering on the not-so-struggling Toronto Maple Leafs. Doing a lot better the last 6 games. They're playing great.
The not so struggling. I
As
like
of
that.
late, they've been pretty good. So,
They should update their jerseys. I don't know if you could fit that on around the Maple Leaf, maybe.
yeah, listen, could be. So today we are going to start with calculating and understanding child support in Ontario. That is our topic for today. I'm going to do a quick dive now into child support guideline. More specifically, what is child support, who pays it, and also provide a brief overview of how payments are calculated.
Yeah, I
So,
think, sorry, just before you jump in there, Joe, I
yeah, for
think
sure.
for those of you who weren't joining us in our sort of water cooler 5 minutes before we kicked this off, this is a huge topic. We get a lot of questions about child support. I know we say this, we've said this every week. We could do like a week-long course on each topic alone. So we're gonna just jump right in and do, provide as much, information as possible. But yeah, Joe, kick it off. What
Yeah, I
is
was ready to go
child
too.
support?
Yeah,
What is
thank you.
it?
Yeah, so when we talk about child support, we're actually referring to the money that one parent pays the other to help cover the costs of raising their child. And this typically happens when one parent spends less time with the child compared to the other, who takes care of them the most of the time, or if they spend an equal amount of time with the children, maybe they make more money. So according to the law, parents are responsible for financially supporting their dependent children. And when we say parents, it's not just limited to birth parents, but rather it can also include non-birth parents, adoptive parents, and sometimes even step-parents. And the parent who pays the child support is known as the payor parent. So that's a term we use quite frequently, is the payor. And parents must pay child support even if they don't live with the children or don't see the children. Now, in each province and territory, they have what's called the child support table. And this table lays out the basic monthly amounts of child support to cover various expenses like clothes, food, school supplies, contributing to rent. And this basic amount is often referred to as the table amount. So how much is paid in child support truly depends on a few factors. Primarily the gross annual income of the payor, so the paying parent, and the number of children they have to support. And when we talk about gross annual income, a lot of people usually sound the alarm or have questions. So, what does that mean? And the gross annual income is the total income a person earns in a year before taxes and other deductions are taken out. So we call this the line 150 income. So that's the number we look at when we're calculating how income should be calculated for in terms of support. So line 150 income, if you go to your income tax return and you go to the line 150 bar, that's the number that we use. Sort of a brief little rundown on what child support is, who pays it, and a brief overview of how payments are calculated. Russ, you want to take us into the income considerations and, really, again, understanding gross income and its impact on support amounts?
Just a few more comments about the guidelines. There's federal guidelines if you're seeking support pursuant to the Divorce Act. There's provincial guidelines, which unmarried couples will refer to, or common law couples. And each province has a different number. Only lawyers come up with something like this, but it kind of makes sense. If you're living in Ontario, your cost may be a lot less to raise a child than in Saskatchewan, housing and vehicle and all the other expenses associated with living in Ontario. And same with Vancouver versus, perhaps PEI or Nova Scotia. So each table has a different amount based on a cost of living. So yes, this is a big one. Again, stuff's 100% right. We could spend hours talking about each one of these, but we want to give our audience a flavor of what you want to be considering. So what am I talking about? Gross income and how that impacts the. It's easy if you're a T4 employee. So what I'm saying is you work for somebody, you get a paycheck, the tax is deducted from your check at the end of the year, line 150 or 1500 or whatever the number is, that says this is what your gross income is for that particular year. So this is before they take the taxes off. And that's the number we use to calculate your child support. Joseph says there's this guideline, there's a table, there's a box, there's online calculators. Give you a rough idea. I don't know if I'd rely on them. So you plug in the income, you plug in the number of kids. That's going to tell you your monthly child support. That's the easy calculation. It gets a little bit more difficult if you're a business owner, for example, or if you have the ability to write off personal expenses that may be paid by a company, and those need to be grossed up. So meals, promotional expenses, travel, you get a car allowance. That's a big one. Most people don't get that. Insurance, cell phone may be paid for by the company. So hypothetically, let's say you get $1,000 a month car allowance. And that's coming to you probably tax-free, and you need to gross that up as part of your employment income because it's a taxable benefit. So you're not spending $1,000 on a car payment. Your company's covering that off. Wages paid. So let's say you own a company and you're paying wages to a related party, splitting income. This is common. Lots of businesses do this, family-run businesses, small businesses. They may have a spouse on the payroll. They may have grown children working with the company. Reduces the owner's taxable income because they're putting it in a lower tax bracket. But that's income available to that business owner. So we need to put that back on, right? Especially if perhaps the spouse isn't really working in the company. They're just showing up once in a while. They have a bookkeeper or whatever the case may be. So you want to look at that. Another big one, which can cause some disagreement amongst parents is unreported cash. Depending on where you live, this could be quite common. I've got a place up north, and small businesses don't give you receipts. They want cash. They don't want to report it. It's almost like subsidizing their living. And other businesses, we had a car dealership. He would sell his cars, but occasionally somebody would pay him cash for a car. So the wife knew that was occurring. We needed to understand how much unreported cash the business was taking in, how much of that we can attribute to the business owner, and then gross up his income before we calculate the child support. You know, landscaping services, trades, hair cutting and nail salons are almost always cash, or at least the ones that I know people go to. They always like getting cash and not paying with a credit card or a check. I don't know if people take checks anymore. Small service companies. So this makes it can make it difficult to quantify the income. So what we want to do in those scenarios is look at the spending and look at the lifestyle. So this small business owner is telling Canada Revenue Agency, I'm making 25 grand a year. But he or she is taking their family on 4 or 5 holidays to the Caribbean. Kids are in private school. You know, they have luxury vehicles. You got to understand, okay, well, how is this person making $25,000 a year supporting this lifestyle? And that's when you start thinking, okay, what's the expense of the assets? How did they pay cash for these vehicles? How are they paying for their trips? You need to do almost a mini forensic audit to try to understand, okay, you told CRA you're earning 25,000, but you're spending 200,000. Okay, there's a gap there. So the court's going to increase your income to reflect the lifestyle that you're living. There may be an explanation. Maybe the person received an inheritance, the family member is paying for the holidays, but usually it's they're underreporting their income. Another one that's probably we don't have enough time to take a deep dive is the attribution of pre-tax corporate income. So this is income that's available to the business, but for some reason, the business owner is deciding to keep it in the business. It's not going to draw it out. We're going to keep it in capital. We're going to pay down loans where ordinarily they would be drawing that income out. We see this a lot after somebody separates, right? They bring their incomes down. They keep the money in the company. Non-recurring one-time sources of income are going to be excluded. Capital losses is a big one. If you're earning $20 million, but you have a $30 million capital loss, you can reduce your income significantly. But you're really earning $20 million when it comes to child support. The capital loss is a notional loss on the books, right? You're not actually losing. You lost $20 million maybe 4 years ago, but that particular year you earned 20. So I'm not sure. We're going to talk about imputing income coming up. Anybody have that covered off? No? So the final point I want to make, and I don't want to step on anybody's toes, what do you do, right? This person, this payer is playing games. You know, court needs to impute income. I had to actually look it up before we started. If you're in Ontario, section 19.1 of the Ontario Child Support Guidelines, you want to look at a number of things you can examine, and if you can prove it on a balanced probabilities, the court will impute income. Underemployment, the person may be tax exempt. The payer may be living in a country with a different tax rate. They may be diverting income. We talked about that a little bit. They may have assets that can generate income that's not. That goes on. There's about 10 or 15 categories that you want to consider. See if there's any other ones I want to talk. We talked about deducting expenses unreasonably from your income. Those are through the business. And they may be a beneficiary of a trust, which we need to consider, which is a whole nother hour talking about family trusts and child support. So that gives you a flavor of what we're looking at when we're talking about gross income. Self-employed T4 employees, pretty straightforward. Business owners and some of these other categories, you want to take a look to make sure this the payer is paying the proper amount and not, they may not be up to mischief in the sense that it's a good business practice, but they're up to mischief in the sense that this income or this income stream is income that we can attribute to that payer, which should be properly considered when determining the correct amount of monthly child support. Back to you, Joseph.
Yeah, thanks, Russ. Just, there's so many moving parts when it comes to calculating, gross income. It's very easy to get lost in the web. So it's really useful to seek out help with respects to knowing your rights, knowing your child's rights, given that child support is the right of the child, to really ensure that adequate income is being provided. So I talked about earlier about the table support, which covers or is supposed to cover the cost of living with respects to shelter, food, clothing, school supplies, things of that nature. But Shanza, do you want to sort of discuss with us what special and extraordinary expenses are?
Yeah, for sure. So like Joe, you just said, so we have the baseline amount of support, which is the monthly table amount. On top of that, we have something that's called the special and extraordinary expenses. They're also called Section 7 expenses, and that just refers to the section number in the guidelines that talk about these special expenses. Essentially, these are expenses that are paid for in addition to the monthly child support amount. So they're not included in the monthly table amount. Table amount is for, like just said, basic expenses, clothes, food. The extraordinary expenses will be for things like daycare, extracurriculars, if there's any special needs of the child, medical health expenses. An example could be counseling, speech therapy. So all of these can be considered special expenses. And this is something that the parents will pay for in addition to the table amount. Mostly Section 7 expenses are divided proportional to the income. So if both parents are earning roughly the same amount, the cost of these would be divided equally. In other cases, we have parents who where one parent is earning more, and in that case, it will be proportional to the income that each parent is earning. If you are separating in your separation agreement, you can agree to what these Section 7 expenses are for your children. You can mention any present expenses. You can also put in any future expenses that you can anticipate for the children. All of that can go into your agreement. How the costs will be divided is also agreed to, and that gets included in the agreement as well. Lawyers can come in and they can help to identify these expenses and what they could be and how they can be attributed to each parent. If you and your ex can't agree, then you can go to court. The court gets to decide for you if something is a Section 7 expense. The court will see if so when you go to court, they try to determine if the expense is reasonable and necessary. And that would include looking at things like your income, how much you make, how much monthly child support is coming in, and then they will look at the expense and they will see how much it costs, if it can be reasonably taken on by the parties, and if they can afford to do so, then it's a reasonable expense. They can also see things like, was this expense part of your family expenses before your separation? But even if they weren't, that's fine. The kids they could have been little when you separated, so there are activities they can get into as they grow older. The courts will usually approve if it's something you can both afford, and if it's in the child's best interest. You do want to let the court know like why you want a certain expense. For example, if you want to, I don't know, hire a tutor, you would want to show that the child needs extra help. And if you want to pay for specific classes, you might need to show that the child has a special interest in that activity, or they have a talent. So you could basically use all that to kind of argue that this can be a Section 7 expense, but this is only if you can't agree. If you are in agreement, you can just have a separation agreement drafted and you can have those expenses listed in your agreement.
Yeah, just to add to that, that's great. So when Shanza says proportional to your income, let's just say we have $100 expense. mom's earning 100,000, dad's earning 10. So mom's going to pay $90 of that expense. That's sort of how we calculate it. A couple things that I see a lot, and you wouldn't think about this, right? I see case management judges say cell phones are a Section 7 expense. They don't want the child traveling on the TTC or at nighttime without an ability to connect with their parents. School clothing sometimes can be an expense, especially back to school clothing or private school. Rep hockey, right? This is expensive. So, you know, the judges will say, well, did little Johnny, I don't know why I always choose Johnny, but did little Johnny play AAA prior to separation, right? And if they did, well, maybe we should continue with that. The other one I see, surprisingly, the kid's never been interested in horses, but all of a sudden they separate and one parent puts the kid in a $10,000 summer horse camp. Like where did that come from, right? That's not something the family had agreed to or budgeted for in the past. So those ones get shut down. But those are just some examples that I see in terms of people actually spend thousands of dollars on lawyers like us to argue over the cell phone bill. That's what parents do. But having these examples, it kind of gives you an idea, okay, this particular expense kind of falls into the category, it's necessary. We were doing it consistently prior to separation, so it should continue. You also see that with activities as well, but I digress. Back to you, Joseph.
Actually, just to sort of branch off on that, something that also comes up a lot when it comes to special and extraordinary expenses is one parent may continue to enroll the child in something without consulting the other parent or without obtaining their consent on something. So we see in a lot of separation agreements a provision that says neither party is going to enroll the child in anything or, you know, sign them up for swimming or dance or horseback riding unless it's discussed and agreed to. And if they can't agree, then you can use a good old dispute resolution clause. So it's Section 7 expenses. It can create such a battle between parents and yeah,
and sometimes that's by design, right? They load the activities up on the other parent's time to interfere with their parenting time, which is sad, but that's a great point, Steph. My tip would be, if you're doing an order or a separation agreement, be as specific as you can in terms of what activities you anticipate and you agree to, and put it in the agreement, because there's going to be a dispute. And if it's vague, say, as the parties may agree, now somebody's just going to sit on their hands just to be difficult and say, I'm not agreeing.
No, for sure, for sure. Also too, I noticed that a lot of clauses in separation agreements, they note that consent will not be unreasonably withheld. And then people are always like, well, what is unreasonably withheld, man? Like, what's reasonable? Like, how? So there's always little things. Sometimes it usually doesn't get broken down to what's reasonable versus what's unreasonable.
It's unreasonable when you have to go to court and the judge orders you to pay costs because you withheld your consent. Now you know that's unreasonable, right? The trip to Disneyland that you want to agree to, guess what? Judge is probably going to find that's unreasonable if you object to it.
For sure. And then, you know, going down, and people are always saying, you know, I have these Section 7 expenses. I have this, you know, these table supports that I'm paying. You know, how long am I supposed to be paying these for? What's the duration of support? And, you know, with respects to duration, child support needs to be paid as long as the child is dependent. And dependent, what does that mean? Really, right? What does being dependent mean? And typically it means until the child hits 18 years of age. But sometimes it can go even longer than that prescribed 18 years. There's a child can stop being independent if they get married, or if they're even 16 and they decide to leave home and do their own thing. But even if a child does hit 18, they still might be considered dependent if they can't support themselves. And this could be because of a disability or illness, or if they're still going to school full time. So it's really important to note that there isn't a strict age cutoff, and that there's definitely other factors that need to be taken into consideration when determining duration of support. Does anyone want to jump in?
I had a case. I actually represented the kid. I think he's 16. Mom didn't want anything to do with him. Dad kicked him out of the house. So he wasn't withdrawing from parental control. The parent withdrew, both of them. We got an order against both parents to pay guideline support to them, which is, I thought was a pretty good order, but it just sort of kind of contextualizes it, right? Supports the right of the child. It's not the right of the parent to get the child support and go pay their car loan. It is designed for the child, but just thought I'd add that in there. I thought it was kind of an interesting twist to withdrawing from parental control.
Yeah, no, that's I didn't even know. That's crazy. I never a lot of people sort of dismiss that, right? But the fact is that the child is still dependent unless they withdraw from parental control. They are still considered dependent. And that brings me to the next sort of topics with respects to enforcement of support. How do we get a parent who is the payor? How do we get them to make sure that they are paying what they're supposed to be paying? And a little tool that a lot of people like to use and a lot of people like to call upon is the Family Responsibility Office, FRO. We spoke about them
That's a little tool.
little tool, a large tool.
That's a hammer.
Yeah, really. We spoke about them last week briefly, but once again, they're sort of coming into the mix with respects to enforcement for support. So FRO, which is the short term for the Family Responsibility Office, is a government agency that plays a role in enforcing support payments here in Ontario. And now with respects to the payments, they can come from a few different places. They can come from a notice of calculation, a written agreement filed with the court, or a court order in and of itself. And FRO, what they do is they basically step in to make sure that child support gets paid, bottom line, as well as spousal support if you tie it all together, but predominantly it's with respects to child support. And they collect the money directly from the payor parent, so the paying parent, and then they take that money and pass it along to the other parent, also known as the payee or recipient parent, who's taking care of the child. But here's the thing. If a payor parent happens to miss a payment, FRO doesn't just sit back and do nothing. They have a lot of tricks up their sleeve that they like to pull out. They can do things like suspend the driver's license. They can report the payor parent to the credit bureau, or they can even cancel their passport. And sometimes they can even have the parent incarcerated as well, go to jail. So they have a lot of serious enforcement power to make sure that those payments get paid.
I had a client say, if I go to jail, does it wipe out the child support? Right? He thought, no, you get out. Still waiting for you. But we did have an audience question. I just want to touch upon it quickly before we move on. How do you get disclosure from a business owner? They were in court. Well, the court can order it, and then now they're in arbitration. Well, the arbitrator should have the power to make those disclosure orders. Just want to touch upon that quickly.
Yeah, and just sort of bouncing off your comment about, if I go to jail because of it, does it wipe it out? There's situations where, FRO will make a deal and, parties will show up at, jail on Friday afternoon, spend the weekend in jail, come out Sunday night so that they can work the week in order to make an income, in order to pay off their support arrears, or the support that's built up that they haven't paid. So it's definitely, I think a hammer is a good sort of comparison for what FRO can be. So
yeah,
for sure. And so today we've talked about duration, we've talked about enforcement, but oftentimes situations change. And you might be in a position as a recipient parent saying, things change. The payor parent's making a little bit more money, or they got a better job. So Steph, you want to talk to us about how we can modify support payments?
yeah, of course. So, if there's a final support order that has been made, it is possible to vary that order or change that order through the courts. So, the good old child support guidelines, if we look at section 14 of that, it indicates that a variation order can be made if there's a change in circumstances that would have otherwise resulted in a different child support order. So, the most common change could be the payor parent's income has increased. They used to make 60, 70,000, but now they're making $150,000 a year. So if they were to do the calculation at that time using their new income, support would have likely been a lot different. Other changes in circumstance could be a move by the primary resident parent, so the parent who has the child in their primary care most of the time. If there's been an increased cost of the other parent's parenting time with the child. So for example, if, they move provinces and in order to implement parenting time, one parent now needs to travel or has, incurred higher costs in order to see the child, that could be an impact to child support obligations. If the child has withdrawn from parental control, like Russ and Joe said, or if they finished a post-secondary degree, or if the parenting time that they were originally doing, so say they were equal and now it's, they're living primarily with one parent and not with the other. So all of those sort of circumstances can impact child support when you're calculating it from the get-go. So if those changes occur over time, child support could be adjusted. So generally, if you don't have an order and you have a separation agreement detailing child support, look in your agreement to see if there's a provision that defines what circumstances could trigger a change or a variation or even a termination of child support. So that's always a good tool, is to look at those provisions if you have an agreement. But if you don't and you have an order, you may have to go back to court in order to vary that order. And another caveat is, if you do have an agreement that details child support, but the amount is not in accordance with the guidelines. So say, you did a kitchen table agreement and you just said, let's just put a flat number in the agreement and let's go from there. But it turns out that that flat number isn't in accordance with what should have been paid to the child or for the child. Either parent can apply to vary that amount, and then a court could make an order for support that mirrors the guidelines, regardless of what the parties previously agreed to. That's why, when creating agreements, when discussing child support, it's really important to try to, find advice, speak to a lawyer so that you get it right the first time. A good old consultation with the lawyer, retain a lawyer, exchange financial disclosure. You want to make sure that you're doing things right, because at the end of the day, it is for your children or for your child, and it's their right.
We got an audience member looking for a second opinion. Stay tuned. Joseph's going to complete your teaser so you can figure out how you can meet with one of our lawyers. Steph, that was great. When I a lot of times in my experience, court orders and separation agreements usually will say, disclose your tax information, they pick a date, May, June, June, whatever it is, each year, and adjust support each year. So sometimes your agreement might have an automatic mechanism to adjust support. If it's not being adjusted and you think you're paying too much or too little, my tip today would be put the other side on notice. So, I want the income information, I want to adjust support, and try to do it in a way that we can retrieve it. So a written letter, a text message, an email. So if you do have to go to court several months later, first thing the judge can say, when did you ask? Say, well, I asked in July when I didn't get the tax information. That enables the judge to make a retroactive adjustment for what was overpaid or what was underpaid. So that notice, fundamental principle of justice, give the other side notice of what you're seeking, ideally in a format that we can provide to the court to prove it, is really important in terms of preserving our rights.
No, for sure.
I've seen cases, 4 or 5 years later, the order said to adjust. They never did. The judge goes back 5 years and you get a lump sum payment of, 40, 50, 60 grand to account for all that missed support.
No, for sure. For sure. It's really important to stay on top of it. And that's why in any separation agreement that you draft and you have one of those clauses, it's really crucial to abide by it. So I already spoke about duration of support and noting that child support typically lasts until the child stops becoming a dependent. But I did mention that the age cutoff is not a strict number. Shanza, do you want to sort of speak to us about support for adult children?
Yeah, for sure. So we kind of like hit on it already. So there are instances where child support can continue past the age of majority. Like Joe, you mentioned earlier, there's two instances. One, if your child is attending full-time school, that's post-secondary education, or if there is a disability or illness, then the child continues to be a dependent child. So the support obligations can continue in these two cases. I'll speak a little bit more about these two instances. So for disability and illness, the rationale is that the child with disability depends on the parents to support them. And to determine the amount of support and the obligation to pay, we will look at things like their medical condition, their ability to become self-sufficient, get a job, is ODSP, I think, are they on ODSP, is funding available, what are the specific needs that relate to their disability. So all of these things come into account to determine how much support is owed, how much it will be, and how long it'll continue for. And when you are determining the amount of support in these cases, the courts will usually start with the same approach that is used for minor children. But then, depending on the disability, they will make adjustments to the amount accordingly, looking at the, like I said, the need, the financial ability of the parents to support the child. If government funding is available, then perhaps child support will address if there's any shortfall between what the funding is and whether the needs of the child, so child support can address that gap. That's the general idea with disability and chronic illnesses. For post-secondary, being enrolled in school does not automatically entitle a child to support. Entitlement and amount varies depending on things like schooling and living circumstances for the child, the parent's financial means, the child's financial means. The court will look at the whole picture to see if the child is dependent on the parents and if child support is needed. It is usually the first degree where a parent may owe child support, but it's not a hardline rule. There are instances where the obligation has continued to a second or a third degree. So if you have a child who wants to pursue a master's program, they want to go to law school, you may owe child support. You want to look at the program. Is it full-time? If it's a full-time program, then it makes it less likely for the child to support themselves, which means you owe them child support. It'll also matter if the child is getting any OSAP, any bursaries, any financial assistance. That will reduce or maybe eliminate the amount of support. There has to be a connection between the first and any subsequent degrees. Courts like to see that there is a career path that the child is pursuing. They can't just keep enrolling themselves and, I don't know, switch from one degree to another with no career path in line. On the other hand, you may have children who are self-sufficient. Maybe they took a couple of years off and maybe they worked full-time and they have become sufficient to the point where it is very unlikely that you owe them any support. So as a general rule, there is an expectation that a child who has worked will contribute towards their expenses. There is no standard formula for what's the appropriate amount of contribution. Every case is different. Every family is different. If the means of the parents are limited, then the child could be expected to contribute, but generally, if the child is in a full-time program, you are most likely paying them child support. But yeah, that's a bit of an overview of how the courts would look at a child in school or if they have a disability or illness.
I went to school with some kids like that. They just kept on getting degrees. They didn't want to graduate. Why would I want to enter the workforce? They're having too much fun.
No, for sure. I was done after two. I thought two degrees for me. I was over school, so I needed the workforce. But Russ, you spoke earlier about the income considerations with respects to its impact on child support amounts. Can you maybe touch on the tax implications and if there are any with respects to child support?
How exciting is that, right? Let's talk about some tax at 6 o'clock on a weekday. Very simple terms. Child support is non-taxable, which means you do not get a deduction if you're paying it. You're not declaring it as income if you're receiving it. Spousal support is taxable, unless it's lump sum. Of course, there's an exception to every rule. So if I'm paying monthly spousal support of $1,000, I get a deduction for that, which means that depending on my income, that $1,000 payment might only cost me $600-700 after tax because I'm going to get a credit for it. My spouse who receives $1,000 needs to declare it, and depending on his or her income, will need, probably only pocket maybe $600-700, depending if they're same income brackets. Child support is just a straight, you're paying the money, no adjustment. So what does there's a bigger picture at play here though. We look at family incomes as a pie, right? How we're going to divide it up. Maybe only child support's in play. That's all we're talking about tonight. But for many families, common law families as well, there's usually a blend of child and spousal support payments going one way or the other. So we look at this pie and we decide how we're going to divide it up, depending on the relationship that was played, the roles, the length of the relationship, a whole bunch of different factors, but it's going to be divided up somehow. Of the recipient spouse, part of that will be the non-taxable child support. The other part will be the taxable spousal support. So we use a program called the Spousal Support Advisory Calculations, which takes into the account the tax rates for each payment and each household. And then it comes up with a formula, say, net disposable income is a fancy way of saying, what piece of the pie are you going to get? Well, you're going to get maybe 52% of that pie because you're supporting the children and you're supporting yourself. So that's sort of, bird's eye view of how taxes apply to child support. The other thing I want the audience to be mindful of, and again, Steph said it, we could spend an hour on each one of these topics. Let's just say the kid graduates, right? They're out of school, they get married. That child support ends. But the pie is still the same. So you might have a claim to increase your spousal support because now there's more money to share. That non-taxable child support is gone. You can say that's a material change. My spousal support should increase to adjust for that budget. Just throwing it out there. I'm not trying to cause any problems. I'm just thinking you want to be mindful of that. This is sort of the analysis and how important tax comes into play when you're looking in terms of what type of payment you're paying and the recipient's receiving, and what's it being paid for, child support or spousal support. So there's a bit of tax for you in 5 minutes or less, but I think you get the flavor in terms of the importance of the tax treatment.
Yeah, and it's so interesting how child support and spousal support can be so intertwined sometimes.
Right.
And just a little plug, next week we are going to be talking about spousal support. So if you do have any questions or want to learn more about spousal support, make sure to register. So that's March 5th, spousal support eligibility and obligations.
And child support takes priority over spousal support.
Yes. Yes, that it does. That it does. Now, today we've sort of thrown around the use of separation agreements and going towards that dispute resolution clause if we have an issue. But Shanza, are there any other options for resolving disagreements over support?
Yeah, I would say generally there are 3 options. You start with negotiations. That's the first step. There's mediation, arbitration as an option, or if nothing's working out, go to court and get a court order. Child support, we've all mentioned this since the very beginning, is the right of the child. You can't agree to not pay it. Both parents are responsible for supporting the children. So there's no contracting out of it. You do want to address anything related to child support. Don't sit on it. Lawyers can help with negotiations. They can negotiate on your behalf. They can help you reach an agreement and guide you through the process. And more importantly, lawyers know the law, so they can help you understand your rights and more specifically your obligations regarding child support. They can explain the legal framework, how it applies to you. Aside from that, mediation is something that parties can consider if there are disagreements. It provides a calm environment for resolving any disputes as compared to going to court, which can be stressful, can be time consuming. Family mediators are neutral third parties, so there is no, they can guide the process, they can find a way to perhaps maintain mutual respect and help agree on what's the best course for the children. And all of this can be done in an environment that is more controlled. Mediation itself is not binding, but at the end of the mediation, if you can reach an agreement, you can enter into a written agreement and sign it, which becomes binding. There are government-funded family mediation services available at all courts locations in Ontario. I believe you get up to 8 hours of mediation, and the fee is it's based on income. There is also arbitration. Arbitration gives similar benefits to mediation. It's different because the arbitrator's decision can be legally binding. It can still be faster than going to court and less stressful than litigating. You can have more of a say in how the proceedings are run, but the arbitrator still has the final say. Lastly, you can go to court. For court, you can start an application. How the process works is you go to the judges and they can make the court order for support. When you start an application, you go through a series of conferences and the judges, they give their recommendations to help the parties settle. You can get temporary support ordered by the court through motions. Motions, they deal with more pressing matters. So that's another way you can get a court order for support. Going to court is usually reserved for high conflict cases. Courts can give temporary relief and they can compel the other party, especially if they're unwilling and if they're reluctant to engage in any sorts of negotiations or ADR. And so going to the court will give them that push and can get you that temporary support order. And you don't really have to stick with any of these options. So for example, you and your partner might not be able to solve your case through negotiations or a family professional. In that case, you decide to go to court. Or if you are already in court and you have started a case, you can still agree with your ex-partner to pause your case, and you can try to reach an agreement. So it's not, you don't have to pick one option or the other. You can, make your way back and forth and whatever works for you and your family to come to an agreement for on support orders.
And thanks, Shanza, for sure. So many options, and sometimes mediation just doesn't work. Sometimes just negotiating with your partner or your ex-spouse just does not work. Steph, how can we help?
Yeah, it's always encouraged to get legal advice because there are so many nuances to support. We've touched on a lot of these components just today, but this is all just a taste of what could impact your matter. The tax implication, how much the income, if your ex-partner's income on their notices of assessment and income documents is a little lower than they may actually earn. How do you impute that person with a higher income when calculating support? We always recommend speaking to a lawyer who does practice in the family law realm. There's criminal lawyers, there's corporate lawyers, but support and child support, because it is very legislated, it's always encouraged to speak to a family lawyer when trying to navigate this issue. It's also important to get legal advice on what circumstances could maybe support child support not being appropriate. When is it appropriate to deviate from table amount? When is it not? Having a lawyer to help facilitate exchanging financial disclosure so that you do know what your spouse's income is and that you're providing the right documentations to support your financial circumstances. And also obtaining legal advice for drafting a separation agreement. We highlighted some phrasing and terminology and the inclusion of defining what special and extraordinary expenses are versus what aren't. What's something that would trigger variation or trigger what's considered a material change in circumstances. So all these little nuances that could be difficult to navigate if you don't do this every day. It's always encouraged to get legal assistance so that you make sure that whatever deal or whatever agreement you're entering into, it incorporates and it takes all of those things into consideration. So the child support that's being agreed to, or if you're in court being ordered, adheres to the guidelines, and it's you know, on the up and up about what your child or children deserve.
Yeah, we
Perfect.
have clients who come back, say, here's the income, what's the new amount? We'll do the calculation for them real quick. But you know, you're right, Steph, there's a lot of unknown knowns there. Even lawyers get it wrong. There's so many moving parts to this, but you want to make an informed decision based on proper disclosure. So that was spot on.
Perfect. Thanks, Steph. It's 5:52. We do have a couple questions, Q&A questions that we can answer. One of the questions here asks, what should I do if I can no longer afford to make my child support payments? Steph or Russ, you want to take a stab?
So that sort of falls into a material change. You know, one of the biggest changes or the biggest triggering factors to change support is the payor's financial circumstances. If you lost your job, if you got injured and you can no longer work, you know, you used to make $1,000, $100,000, but now your income has dropped because your company had layoffs, and you know, you can only get a job that now you're making 60,000. That's a significant change in income. So depending on if you have an order or an agreement, that's going to sort of impact how you navigate making that change or requesting that change. But definitely speak to a lawyer and they'll help you navigate whether you're pursuing a variation order or you're pursuing a change in your agreement, because it can be quite jarring, I would imagine, right? You've been paying support based on a higher income and now you're struggling. So it's definitely important to deal with that and deal with it as soon as possible.
You know, what I would ask, Steph, is why can't you pay it? You know, maybe your income didn't drop, but you went and bought a more expensive home. Or the interest rate's wiping you out because your mortgage payment's higher. Or maybe the kids are living with you now. Maybe the other parent should be paying you support. So, you know, ask what is causing you not to pay this? Drop of income, lifestyle, addiction, gambling, new partner. That's going to inform our advice in terms of how you change it or whether it can be changed. Lots of people come in the office and say, oh, this is hardship, I can't pay it. Well, the guideline is pretty specific. Everybody earning your income pays that amount for child support unless the parents agree to otherwise. Hardship is a very high test to meet in court. And simply saying you don't like it doesn't amount to hardship. So we would want to know more to get a better understanding. You've got options, but we need to know more to let you know, maybe Steph's right. Maybe you do a motion to change. Maybe you just pick up the phone and talk to the other spouse. So here's my income. This is the new amount. They'll probably just agree to it. Maybe not, but that wouldn't hurt either.
No, for sure.
But I like your suggestion, Joseph. Give notice, right? Put them on notice. So if you can't resolve it, you can go back to the judge, say, well, I did notify them. And here's my text message or my email. And that opens the door for the judge to go back in time and make an adjustment retroactively.
For sure, Russ. And you spoke about a new partner. Sort of ties into another question that we got. Someone asked, does remarriage or having more children affect my child support obligations or entitlements? Shanza, do you maybe want to answer that one?
Yeah, no.
Don't sound so excited.
Keep paying more.
You're not getting out, sorry. Yeah, but generally no, any changes like that in living conditions or having a new partner will not result in a change in the table amount. This is because the payer's obligation is to the child directly. I'm thinking there could be an indirect effect on Section 7 expenses, maybe through changes in circumstances. Maybe the new spouse helps with post-secondary or there's new medical or dental insurance coming in. But I think that's pretty much it. Generally, the answer is no. Just because you're remarrying, you do still owe that child support, and it is the right of the child.
You might have a better argument if it's spousal support and the recipient remarries and there's a provision in your agreement, but I agree with you, Shanza. If you choose to have more kids, it doesn't reduce your responsibility to your first batch.
No, that's for sure. Do we have time for one more or?
We've got time. Come on,
Okay.
another rip.
Perfect. So we got another question.
It's not last call yet. It's
No,
just
no.
after hours.
Another question we got is, can child support be agreed upon outside of court and is it legally binding? So we spoke about it a bit earlier today, and you don't have to go to court always, right? You can make these agreements outside of court, and oftentimes separation agreements are done outside of court if they're not through a court order. So short answer, yes, child support arrangements can be made outside of court, and yes, they are legally binding. However, though, certain conditions must be met. We talked about it today already. You cannot contract out of child support as it is the right of the child, not the parent. And as well, the child support amount must conform with the child support guidelines, whether that be using the federal support tables if you were married, or using the provincial tables if you were common law. And if parents choose to agree to terms respecting of amounts of child support that deviate from those guidelines, the court will prioritize the best interest of the child. And what does that mean? Court intervention is definitely possible and may be necessary to ensure that there is adequate financial support for the child. So really important, you cannot deviate from those numbers, you cannot pay less, but you have to pay what is legislated by the government. It's really important.
Yeah, I think if you're going to get your divorce order, if you're married, the judge will want an explanation as to what's being paid for child support. And there are some circumstances where you can deviate, like if your travel costs are higher. The parent who has the child with them the majority of the time moves, and now the parent who has contact order or access has $1,000 in fuel expenses. That might be an appropriate set off. But if you're getting a divorce, you need to specify why it's different and satisfy the judge that it's in the child's best interest. The travel cost is you can understand that, right? Because it's in the child's best interest to have a good relationship with both parents. You put gas in the car, you're not going to get there. So that makes sense.
No, yes, for sure. So many different moving factors. And like we said earlier, there's so much you can miss. So it's really, really important to reach out to a family professional near you to get the right answers and to know how you can maximize you and your child's rights. It's really, really important. So on that note,
hour, bring the train into the station, finish
exactly.
your off. Okay.
You like that, right? So everyone, it's almost 6 o'clock. So thank you so much for joining us today.
Okay, everybody have a great night. Thank you for joining us today.
Yes, thank you so much for tuning in, everyone. See you next week.